to 1. Dear colleagues, good morning. We are starting the session. And just to inform you that in this session we have participation of the members of the PCIe, Robert Hein Broekhuizen, the chair of the PCIe, Norman Aas remotely, Mary Kay Butler remotely, Gabriela Jitkaite-Breskene, John J. O'Sullivan, and Jessica Lott Thompson. And also we have Michaela Bonis, Roslav Buch, Ярослав Дух, Надія Кобецька, Олексій Мельян, Андрій Пасічник, Руслан Сидорович, Сергій Чумак, Галина Шевчук. And I'm the chair, Andrei Pasechnik, of the HQCJ. We have also Natalia Vlasenko, the secretary of the commission, and we have the quorum, that's a special joint session of the HQCJ and the PCIe, and it's announced to be open. To inform you that this special joint session, which is streamed online, and we have the following issues for consideration today regarding the compliance of for the candidates of the positions of the judges of HACC with Part 4, Article 8 of the Law of Ukraine on the HACC. And the candidates with whom we are going to have interviews today, that's Mr. Rubashchenko Mykola Anatoliiovych, Madam Kuzina Irina Vadimovna, Mr. Ostapenko Dmitro Mykolaievich, and Mr. Gryn Nazar Grigorovich. Are there any other suggestions for today's agenda? Ludmila Volkova notes down that there are no other suggestions, so please vote if there are no other suggestions. Who is for such agenda for today? The decision is made unanimously, and the agenda for today has been adopted. Dear colleagues, regarding the rules of procedure, so the agenda, we suggest to have it as it was yesterday, 40 minutes for PCIEs and 20 minutes for HQCJ, 10 minutes for general discussion. Are there any objections, suggestions, comments? If not, then let's have it as it was. Please tell me who we have among our candidates right now here. At this session, we have invited candidates for the position of judges of the HACC, specifically Mykola Anatoliiovych Rubashchenko, Irina Vadimovna Kuzina, Dmitro Mykolaievich Ostapenko, and Nazar Grigorovich Gryn. Thank you. Please invite Mr. Mykola Anatoliiovych Rubashchenko. Good afternoon. The issue of consideration of compliance of a candidate, Mykola Anatoliiovych Rubashchenko, with provisions of Part 4, Article 8 of the Law of Ukraine on the High Anti-Corruption Court. Here we have representatives of the PCIe, Robert Broekhuizen, chair of the PCIe, and Norman Aas remotely, Mary Kay Butler remotely, Gabriela Jitkaite-Breskene, Jessica Lott Thompson, John Sullivan. We have also representatives of the HQCJ here in all its composition. You have a right to submit the recusal, submit a motion, provide explanations, and, if it's allowed, to express your concerns and reflections and challenge all the decisions of the Commission as envisaged by the legislation. Do you have any recusals? No, I don't have. The rapporteur of this candidate is Mr. Omelan. Over to you. Thank you. So, Mr. Rubashchenko Mykola Anatoliiovych, born in 1989, a citizen of Ukraine. In 2011, he graduated from the Yaroslav Mudry National Law Academy and has had received full legal education with the qualification of a lawyer. And in 2015, he defended the PhD and thesis on the topic of criminal liability for encroachment on the territorial integrity and inviolability Reliability of Ukraine, receiving the PhD status. In 2020s, he was awarded with the title of Associate Professor of the Department of Criminal Law, and he received relevant documents. He has started working since 2014 as an assistant lecturer of criminal law, Yaroslav Mudry National Law University in Kharkiv. In 2019, he has received the position of Associate Professor of the same faculty. He has also worked part-time as Associate Professor of Criminal Law and Procedure at the National Aviation University, but only for 6 months as during 23-24. He was also a self-employed person. Regarding his work as an associate professor at the National Aviation University and as a private entrepreneur, we are going to develop on later, as we have some questions to the candidate. It was also mentioned by the candidate that he is a specialist in the criminal law. He's interested in all issues related to different spheres, including those covered by jurisdiction of the HACC, and for all his professional work, he has been working actively on drafting legislative acts, and he is also a member of of a working group on drafting a new criminal code of Ukraine under the specialized committee of the Verkhovna Rada of Ukraine. A special check has been conducted against the candidate, and there is no information regarding negative decision of his non-compliance with requirements. And also yesterday, we have received a request from the CSO Center of Corruption Fighting, and I think we can discuss it later during our interview today. So thank you. That's basic information regarding the candidate, and that's all from my side. Thank you, Mr. Robert. Over to you, if I may. Sorry, just to clarify, I'm not a member of the commission on drafting the criminal code. You know, that's a very responsible role. No, I have contributed only in some context. Thank you. Mr. Robert, over to you.
Thank you, Mr. Melian. I now pass the floor to our rapporteur, Gabriele Jubek.
Thank you. Yes, thank you. So, dear Mr. Mykola Anatoliiovych, I would like to give you several questions. And first of all, you in your application documents indicated 5 things that you are honored about. So maybe you can comment more broadly on them.
Yes, thank you. Yes, indeed, those things that I'm honored about, or that's first of all my academic activities, that's that I contribute constantly to different academic studies. First of all, there's in protection of rights of the state in the criminal law, and here I'm speaking about my thesis on the topic of criminal liability for encroachment on the territorial integrity and inviolability of Ukraine. I'm also speaking about the issues of collaborationism, which is very, acute topic. The state traitors and other things. The area of corruption. These are all studies to which I contributed and which I'm proud of. And yes, indeed, that's what I have been doing, and that's what I'm proud of. And yeah, I was also one of co-authors with other scholars of my university. And another thing that I'm also proud of, that's my cooperation with different CSOs and other organizations such as National School of Judges of Ukraine, High Bar School, where I provided different workshops for lawyers and judges correspondingly. And that's also as one of the aspects, and I'm proud that I'm a person who provides different pro bono activities, and I call my friends also to do such activities pro bono and to do the same thing. If you have any other clarifying questions, please ask. because that's, like I'm recalling my memory, and that's what I mentioned in my questionnaire, in my documents. I tried to remember what I indicated there.
Thank you. So, as you already mentioned in your oral presentation, that you were one of the members of working group who drafted new criminal law, and also other not member. Okay, but nevertheless, you are interested.
Почекайте, секунду.
Sorry for a second. We have a working group on issues of a new criminal code. There, I was an expert, a national expert on evaluation of certain things. And another thing that I was a member of a working group, initiative group, as a formal name, on drafting a draft law on criminalization of certain issues. Yes, that's indeed. I was a member of that working group.
So you are interested in criminal law, in the activities that are more or less related to the corruption issues. So how can you define the corruption as a phenomenon?
Sorry, please clarify the question. How do you define the corruption, or what? The corruption aspect of what? Can you please clarify the question?
How do you understand, and how can you, what is your definition of the corruption?
So the corruption actually is envisaged in the Article 3 of the Law of Ukraine on Prevention of Corruption, and it's defined through three sections of different actions. So the first thing, that is what is called as de facto the corruption, which is usually mono-corruption, so or from one side. So when a person envisaged by Article 3 of the Law of Ukraine Prevention of Corruption to use and abuse their powers or duties in order to receive some benefits for them or other persons. That's first section, and there are two other sections which are interrelated, and it's about bilateral corruption, which is passive and active could be. So here we're speaking about giving a bribe or receiving a bribe with an intention to force or push a person envisaged in Article 3 of the Law of Ukraine Prevention of Corruption to abuse their powers or duties, and in reverse, that's to receive a bribe or by a person envisaged in Article 3 of the relevant law for the sake of interests of this person or third persons. That's all. Thank you.
So let's go to another topic. As we understand, you are lecturing in National School for Judges of Ukraine. Yes?
I'm engaged. It's not on a permanent basis. I'm engaged upon the invitation requests for the Kharkiv regional branch of the National School of Judges of Ukraine, starting 2022. During 2022, 23, 24, I provided it pro bono as a volunteer, and in 2025, it was already done on the paid basis twice.
And on what topics you perform your workshops?
In all cases, it was dedicated to corpus delicti of crimes against the national security of Ukraine, and specifically on the collaboration activities.
Thank you. You also said in your motivation letter that you see lack of justification in court decisions, and often even the disregard by judges of the provision of legislation and legal principles. Have you found such examples in court practice of high anti-corruption court?
Thank you for the question. In the practice of high anti-corruption court, honestly, I can't remember it once. even though I cannot say that I have seen all the decisions that were delivered by the chamber, but actually I saw many of them. But I can't remember because even in my publications, frankly speaking, mostly I covered issues on crimes against national security. So that is why I haven't really criticized High Anti-Corruption Court even once. I can't say that there are no problematic issues, but as a researcher, I'm sure that there are lots of publications, including others in the research community, that can be pretty ambiguous about certain issues that the court delivers opinions on. And as a researcher, I mean, I'm not trying to protect myself, and I cannot say that I have nothing against the court. I'm the researcher. I understand that I'm covered by the requirements of the law, the status of judges. So I have to be to comply with the ethics, but mutatis mutandis is used here. So as a researcher, I'm obliged in my own research works to be the researcher. I cannot but criticize the court if I do not agree with their opinion. But if I become a judge, then of course it is inadmissible. But as a researcher, I mean, it's my obligation as a researcher not to agree with things, even with the decisions of judges. As for decisions of High Anti-Corruption Court, I don't have that many articles or analytical materials that are dedicated to anti-corruption issues. My experience of teaching in anti-corruption is mostly associated with with being a co-author in developing a discipline back in 2017, which has been taught for a long time, and the name is Qualification of Corruption and Corruption-Related Offenses. And I was a lecturer, and I also delivered practical courses in this discipline. So that's my main foundation. As for my professional connection, and that's why I'm actually participating in this competition.
Thank you. And also you indicated, we can see from your documents that you are lawyer analyst in NGO Institute of Legislative Ideas. Yes?
Так, я, так би мовити, член команди Інституту законодавчих ідей в широкому розумінні.
I'm not really working according to a labor agreement here with this institute. I'm just an expert, but of course at various events, in various publications, I speak on their behalf as a member of the team.
And the question is, could it lead to some conflict of interest if your participation in this if you will be successful in this way? Do you understand?
Ну, сподіваюсь, що зрозумів.
Hopefully I do.
Could it lead to any conflict on interest in your future work if your participation in this competition would be successful?
Дякую.
Yes, thank you. Actually, I believe that in general, avoiding a conflict of interest, no matter what activities you are engaged in, I mean, I believe it's impossible. If you used to work at least somewhere with some team, actually there's going to be an issue about the withdrawal and self-withdrawal, even if, for example, you take colleagues from the university, not my colleagues from the Institute of Legislative Ideas, but from the university, which is my main job. If, for example, they are parties to the proceedings, again, there is the issue of conflict of interest. So, I mean, the direct answer to your question is yes. Of course, conflict of interest can emerge if somebody becomes a party to the proceedings. But if it's extreme, an extreme case to make the situations like that impossible in a wide sense, or like to have more serious risks, the conflict of interests, I don't see that. Even though the Institute of Legislative Ideas for a long time has been among the main NGOs that dealt with the expert assessment of anti-corruption legislation, the law drafts. And by the way, I also provided some services when I still worked on a free of charge basis. It was back in 2021 and 2022. When I just started communicating with them, it was still, as I said, a voluntary job. I provided opinions, my own ones, to law drafts, because they analyzed those law drafts in the Verkhovna Rada and tried to find corruption risks in those. But again, I believe that there is no extreme or exceptional risk of the conflict of interest compared to any other type of activities that you do before you occupy a post of a judge.
Thank you. Well, now I would like to ask about the increase in assets in savings. The deviation was found in 2024 and 2023 declaration because you have more savings in foreign currency and less in hryvnia. Can you explain this?
Чому саме більше більше в
Why
іноземній,
more in foreign currency,
чому відбулося збільшення?
or why there was an
There are
increase?
some deviations in both ways, in increase, in the decrease as well.
В частині, скажімо так, в частині моєї фінансової стратегії,
In the part of my financial strategy, I believe that you also have your own financial strategy, but my strategy envisages the following. Given the dire financial and economic situation due to aggression from the side of Mordor, our neighbors, we need to have common sense and to have some foundation. So I'm saving that money, and also I'm trying to convert them in foreign currency because I believe it to be more sustainable. That's part of my financial security. I have no real estate, I don't have any vehicles, I don't have any other valuable movable property, even though I'm already 36 years old. You may ask, like, what do you actually have? But that's all that I have, my savings. And if we're talking about deviations in 2 years, if we take this aspect 2023 and 2024 respectively, I explained and I showed actually even with regard to taxes, because of course I don't only take into account the money that you get nominally, so to say. I also took into account the money that back in 2023 I received with the taxes and fees deducted, and also deducted the remainder that I had as of the 31st of December the previous year. And I demonstrated in my answer that actually most of this money I did convert into foreign currency, including the remainder that was in cash as of the end of 2022. It was either spent or it was converted into foreign currency. Most money is preserved in banks, it's not cash. Banks have respective documents. If it's about the state of my savings as of the 31st of December 2025. I hope that I answered to your question, if I have understood anything.
Yes, and one additional question, could you list your sources of income for the last years?
Yes, the biggest income in 2025 was from my entrepreneurial activities, salary ranks second, and the third place is taken by other revenues, in particular from agreements with the National School of Judges. There was also a small sum there because there is a service actually for 4 or 5 years you can replace, for example, an old model of a, you can substitute your old cell phone with a new one, and they actually pay you for giving up the old phone. It's something like 1,200 hryvnias. So that's why I got these revenues. So that's from actually this kind of exchanges of property. So when I did this exchange, I actually asked for documents to be provided to justify, and I have these documents. Actually, there were even taxes and charges deducted from those sums. What else? I don't remember. Oh, yes. There was cashback, bonuses from the bank, or the national cashback from the state. So I think it's it. That's it. It's just, I may be somewhat like in memory, but anyway.
Can you give some examples of, you mentioned entrepreneurial activity, so some examples, what type?
Так, ну це така доволі складна діяльність, яка в мене
That's rather complicated activities that takes all my weekends, nights, evenings, the days when I don't have that many lectures or classes in the university. That does damage my personal life and health, I have to admit, but I understand that now I'm in the peak form of development and activity. If you have knowledge and skills, you have to invest. Nobody is going to come to you or tell you that, okay, please take that for you. So you shouldn't be just waiting for something to be given. You have to work for its sake. So from the point of those obligations that I have, it is about providing consultations on legal issues. Sometimes they are oral, but mostly they are reflected in our research. It is about analytical materials. On the website of the Institute of Legislative Ideas, you can look at those. There is a chapter of an analyst. You can enter my last name, and in this chapter, in this section, you can find my articles. This is analytical research, which is financed from internal and external sources. I don't really know too much about that. That's what I can say in general, because, I mean, we conclude an agreement to provide respective services, and under this agreement, I understand what is this project. We are discussing what I have to do. So, like, as examples of analysis that I'm proud of, that actually took a lot of time and effort, but I'm proud of those. That's analysis about transposition of the EU Directive 1226 back from 2024, which concerns the punishment and defining violations in adopting sanctions. This is also about the improvement of targeted confiscation of assets due to a violation of sanctions. That's also analytical materials that concern the review of EU Directive 1226. There were several of those. What else? Apart from that, it is also about advocacy, because you speak at different events, which also require some preparation and some effort, because you participate in the events where representatives from different state authorities are present. And you have to understand those issues which you propose because you advocate respective changes which are dictated by practice, best practices of partner countries and directives of the EU.
Thank you. And the last question from my side is about the declaration of your property. In one chapter, you indicated that your place of residence is in Kharkiv at the address 57B and so on. You know about what I am talking about. 57B, Peremochi Avenue, yes? And your actual place of residence is in the village of Mironivka, Kharkiv region, Gagarina Street 17. And in another chapter, you declared only the right to rent an apartment. So can you clarify this situation? You already answered, but just the audience.
Так, я розумію, що публічно це потрібно.
Yes, I understand that it has to be explained publicly, and the society should know about it. Just allow me to clarify, is it about 2022 or
24.
because they were different? Okay, so first of all, the declaration back from 2022, there are 3 real estate objects that there was the right of use about. It's not ownership, it's right of use. The first type of real estate is a room in a dorm. Since 2006, I lived in that dorm of the National University. First, it was a student dorm, and then the so-called family-type dorm. So it's for teachers, so postgraduate students, so it could be families, for example, families of students. And also in 2022, in the beginning, before full-scale invasion, I lived there as well, based on an agreement with the university and the Transfer and Acceptance Act of providing that bed for me. When full-scale invasion started, on the 24th of February, I took some things, just literally a backpack, and I went to my parents, who are located in the Kharkiv region. They lived there. And I lived there until the 5th of September 2022. Why I note the dorm in this declaration? That's the first question, I guess. Because I came with a small amount of things. My things remained there. I paid for my bed there until July inclusive, and the rent agreement for the room and the act was valid. I was actually registered there de facto since the 21st of February and until the 5th of September, and even until now, I don't live there anymore. But until the end of July 2022, I had the right of use, which is confirmed by the documents, and I actually made payments, and my things were also stored there. So I had to indicate that I had the right of use of this type of real estate. But in the end of July, I don't really remember the date, but for sure I know that it was July, and for sure I know that I paid until the end of July for utilities. So I contacted the head of this dorm. I came there, and also I took my things from there. He took my keys, sealed the room, as they say. There is actually the seal with the paper there. That's it. So since that moment, I didn't have any right of use. I mean, I'm still registered there, but I cannot just come and enter that room. I have no right to use that. And also, there is even an explanation from the National Anti-Corruption Service that if, for example, you have registered housing, but you don't have the right of use, then the person shouldn't indicate that as real estate. And that's why I didn't know this object of real estate afterwards. The second question concerns what I wrote in declaration for 2022. It was a village house of my parents, but instead I didn't indicate it back in 2023 and 2024. As I explained, from the 24th of February until the 5th of September 2022, I lived at my parents' place. Actually, my father is the owner of this house. This is a regular village house with a yard, standard classic.
and the yard which is adjacent to it. I lived there on the right of free usage and based on relative relations and agreement of my father. I lived there for more than 183 days, and according to the NCP explanations, if you live more than 183 days, you shall indicate this place, this property. I had the right to use it free of charge, this property, and that's why I needed to indicate it. That's why it happened like this, that there were three property objects indicated. So the rights to use two properties, they overlapped. They were in parallel. So I had the right to use the dorm room, but de facto I lived at the house of my parents and lived there free of charge. And since September 2022, I relocated because the studying process started and I needed to have a good internet connection. And you know, at the rural area, internet connection is not that good. And I have online learning process at the university till now, and I need to have a good internet. In Kharkiv, I didn't see that it was safe as I wanted there to be safe. And that's why I decided to relocate to Kiev. And my friend also relocated to Kiev at that moment. I've got in touch with him. I don't remember actually who first offered that, but together we decided that if we relocate to Kiev, then it's better to rent an apartment together for the starters. It will be easier. It will be easier both from the perspective of paying utilities and paying a rent fee, because you divide it for two, so that's a two-bedroom apartment, one bedroom for him, another for me. And that's first issue. And secondly, you know, this city was a new one for me. Before that moment, I had visited Kiev only a few times and only just during a transfer from one place to another. So yeah, I'm not afraid of relocating to city by myself. Yeah, before 2022, I had visited Europe also alone. No, sorry for interrupting. Please be more concise because you go into details, you know, which are very interesting, but not that. Yeah. So I hope that I explained. If not, again, please clarify or ask a follow-up question. I'm ready. I'm ready to speak for more and more, you know. So yeah, please interrupt me if I speak too long.
So thank you. I finished from my side.
Thank you, Gabriele. I'm just looking at the other members also on the screen. Is anyone a follow-up question? Yeah, I always have a follow-up question. Maybe it's also my job. I wrote down, but I'm not sure, but I did it correctly. I wrote down that you said that it is your opinion that there is no increased conflict of interest risk if you are a judge. Is that what you said? Is that correct?
Я сказав, що
I said that
в контексті моєї
in the
діяльності
context of my activities at the Institute of Legislative Ideas, or let's say it so, in terms of my connection, ongoing connection with this Institute of Legislative Ideas, it will not create a risk for increased, sorry, it will not create an increased risk for conflict of interest in comparison with any other activities. That's what I was meaning when I said this phrase, this wording. So the potential risk of conflict of interest that, you know, that I, for example, work at the National University of Yaroslav Mudry. So the risk will be the same, not higher than in comparison with anything else.
Now I understand. Can you tell me whether you believe that if you would be elected as a Hak judge, you would be subject to possible risks of conflict of interest?
залежно від обставин.
It depends on the circumstances. I think that any candidate
Okay.
Окей, давайте продовжимо. І якщо
Let's continue. And if there is no connection with interpreters, so you can hear interpreters, great. Let's continue.
Так, я повторюся, що вважаю,
Yeah, I will repeat myself. So I think
що кожен кандидат
that each candidate for the position of a judge,
конкурсі він не брав участь,
independently on which competition they participate in, they have risks of having a conflict of interest when they are at the position of a judge. Because anyway, each candidate for the position of judge, they have family members, close persons, per previous activities at different positions, roles, entrepreneurial activities. So such risk could appear in any case. The most important thing is to identify such risks in a timely manner and to comply with provisions of the law on prevention corruption, on the conflict of interest, and the provisions of the law on the status of judges. I hope that I answered your question. That's what you wanted to hear in reply.
Yes. Yes. When I'm listening to you, I'm wondering whether, let's say, referring to the laws will help you the moment that when you're a judge and you have an issue before you with someone important who's being prosecuted and you're a member of the Hague, and you will be called by someone and he will say to you, you better be favorable for me because otherwise there will be an issue between you and me. So what would you do when that happens?
Якщо звертається з
If
проханням
anyone approaches me with any request which is related already to interference on my judicial activities, so to my implementation of judicial duties in a specific case, and that's specifically interference in administration of justice. And I need to inform the Prosecutor General and High Council of Justice within 5 days. It's unacceptable. So first of all, I need to first explain it to this person immediately that it's not unacceptable. It's not acceptable. And secondly, I need to comply with provisions of legislation and to report. But if you mean another station, when, for example, the court proceeding is already ongoing, and during this court litigation, some circumstances are being identified that the judge realizes that he or she has a conflict of interest with another party to the proceeding. He has another issues on the table, where there is a reasonable doubt regarding the impartiality.
Sorry, but you
What do you mean here?
legal. The question is, you are a judge. You're sitting on the bench. You have a case with someone who is accused of corruption. And you are one of the judges and you are called by someone you don't know. And he says to you, you better act favorably for me because otherwise, what would you do?
Бо інакше,
or otherwise. If it depends on how this person identifies himself. If that's a party to the proceeding,
He doesn't identify it. A threat is issued to you. You are a judge. And you sit on the bench. The guy is the defendant. Someone calls you. If you don't act favorable for this defendant, something bad will happen to you or your family or whatever.
Ось це я зрозумів.
okay, now I've got your point. Then we need to reach out to law enforcement authorities to ensure safety of our close persons and family members. That's the first thing to do. But the priority is also about interests and rights of justice and professional activities over all other issues. But I understand it's a challenging issue. I don't want to imagine even such situation. No, I don't want even to imagine, such cases in which judges could be.
It happens. It even happens in any country in the world. I can tell you that.
I realize it. And that's why the top priority is to reach out to relevant law enforcement authorities and to take measures to ensure safety of relevant persons, including family members or close persons. But from the perspective of decision-making, in this case, if a judge makes a decision based on such a threat, such a verbal attack, it doesn't cancel responsibility from him, doesn't withdraw responsibility from the judge.
Okay. I will hand the floor to you, Mr. Chairman.
Дякую.
Thank you.
Олексій, напевно, що у вас
Alexei, maybe you have some questions. Yes, indeed. So I will try to be concise, although I have quite a few questions to the candidate. So first of all, I wanted to clarify your motivation, because you also participate in the appellate court competition. You also submitted for participation in a competition in the Kharkiv court. So my question to you is about priorities and why is it so? Yeah, indeed. I had some self-reflecting process and I asked myself, what shall be the choice for me? So here, two things, and very concisely. So first of all, of course, and I can say that there is a certain balance. So I can't say that there is a general advantage either of the HSCC or Kharkiv appellate court. So it means that it's the same for you. No. It's not the same. I'm not indifferent. I decided specifically to participate only into these competitions. But, everyone would like to, to listen to my answer. So if there is such a situation, which court I shall opt for? Maybe my answer would be unpopular, but I would prefer Kharkiv appellate court. Thank you. Then my further questions will be related to your property status, property integrity from one perspective, but they will be also overlapping with your professional qualifications due to certain drawbacks of documents that you filled in or situations which you faced. But that's again only my opinion, without any bias. So my first question is related to the composition of your family in your 2022 declaration. So please tell me, what's your relation with your brother Sergei? Good, where he was living in 2022. He was living in 2022 the same as I was. So starting 24th February, together with him, we have relocated to Marinivka village, Kharkiv region. I know why you're asking about it. Sorry, please do not assume what I'm going to ask next. I will ask it right now. So if this person lived with you, even more to say in your mom's declaration for the period from 2017 to 2020, 2020s, your mom was indicated as deputy of the local council, and your brother had been living with you. So there was a family of 3 members: mom, father, and 3 kids. In 2022, you failed to indicate this information, but now you're mentioning that he had lived. So he had lived during 2022 less than 183 days, starting 24th of February to 5th or 6th of August, I think, of 2022. He had lived during that period. What happened on that day of the 5th of 6th of August? He relocated back to Kharkiv. So before that period, he had lived there, and actually this information is available about him at my judicial dossier. So he worked in the city of Kharkiv before, and he had worked before. But again, you're answering in advance. So how it happens that without changing his place of work, he had constantly received his remuneration, but staying in Mironivka? He worked remotely. He's a manager. He doesn't need to be offline. He's manager, and he was working provision of support to clients. Thank you. My next question is related to your preconditions, to your reasons to indicate property objects, and how those property objects are linked to the composition of your family. So you have indicated it in your declarations, and I'm speaking about the following periods. Sorry, I didn't get your question. So the NACP explanations say that you need to declare the property if you use it more than 183 days or as of the last reporting day. So please tell us, what was your reason to declare this property in your declaration? So first of all, the composition of my family: mom, father, and me. We had lived together, so I had lived together with them more than 183 days. So I was counting those days when I filled in that declaration, how many days I had lived, looked at the photos, my brother gave me information when he left that place, and that's what I used to do that math. Okay, so it was 183 days and more, and I also mentioned the dorm. So de facto, I didn't live it. I didn't live there. I'm not asking you about the dorm. And the third property object, I lived during the 30 last days of the reporting period. That's why I needed to also declare that third property object, because on the last day of the reporting period, I had lived there. My next question: why you failed to indicate contact details and bank details of an owner of an apartment of Kyiv, in Kyiv, where you lived? Okay. Now I understand. So I found information about the owner of the apartment in Kyiv in the register of property rights, and I looked at this information in that register in 2023 when I filled in the declaration. I don't know whether it's accessible right now, but at that moment, yeah, on the paid basis, I can have access to this register, and I got that information. So to confirm renting of that property, you provided us with a renting agreement which was concluded on 4th of September 2022. And in your explanations, you mentioned that starting 5th September, you started living there in that apartment. So tell me, please, why in that agreement the owner was not mentioned, the owner of that apartment was not mentioned? So de facto, as a lawyer, I am aware that this written agreement, has no significance at all in a court, potential court litigation.
Actually, I'm just potentially subsuming that. Because yes, the agreement is signed between a friend of the father of the apartment's owner and my friend, who initially started living in this apartment. I understand that this looks strange, but I sincerely explain just how it is. Okay. I also don't have understanding about the date of the start of use. Today you said that you, together with your friend, decided to go to Kyiv. Yes. Now you claim that, and live together. Yes. So in the agreement, you said that it was concluded by your friend, and you didn't really take care of the issue. No, and this is confirmed. How did it happen that actually on the day of the agreement, you actually started to live in there? He came from Kharkiv. I was traveling from Mironivka, so I came a bit later. How was your journey to Kiev happening from Mironivka village? First, a suburban train. Okay, in full. My father took his car and brought me in his car to Pervomaisk. Now it's called Zlatopil. There is a suburban rail station, Likhachovo to Kharkiv. So that is actually your journey, right? Through Kharkiv. Yes, on the following day. But your friend actually went out earlier. Yeah. And immediately, starting from the first day, rented an apartment. Yes, because this was an agreement with the real estate agent. He talked to the real estate agent. Well, then I have a question. Why the person who rented out an apartment noted your friend in the agreement and not the... No, that actually your friend is somebody who rents out an apartment in the agreement. You provided a copy of an agreement. Presently, you are in these relations. I mean, you claim that now you're already paying full volume of rent payment plus utilities. Obviously, this is done based on this agreement. Yes. This is the document that I really had, and I actually... Maybe there was a confusion there in the agreement. I haven't looked at it. So even at that moment, you also were a party to that agreement. Yes. So you are trying to become a judge of the higher and specialized court. In 2022, you enter in certain relations which are hard to be called very orderly from a legal point of view. I agree. How can this characterize you as a professional? Well, honestly, at that time, when it was back 2022, I understood that I was not a candidate for the judge. It was in 2023 it was announced. It's just that, I mean, I have communication with the neighbors, with the head of condominium. Okay, good. Okay, thanks. The following question. In 2022, what is the size of the land plots that your father cultivated? In which year? In 2022. Probably the same. 5.8, 5.5, I think. 11. Can you just tell me the size of the land plot which was cultivated? This is about the agriculture. I assume here that... Yeah, I'm not going with this. Okay, is it 12 or 11 hectares? Okay, now I look. I just don't want to deceive you here. There are two land plots there. Okay, good. Well, that's not important. 11 and something. Okay, let it be 11 hectares. You note that the income obtained by your father during the year of the use of those land plots is 16,000 hryvnias. And you also note that this was the income directly from growing agricultural crops. Yes. So could you tell me how did the father actually work with the 16 hectares? Was it mechanized? Was it manually? As far as I know, again, I'll repeat that I'm trying not to work with this issue since 2019, because we didn't agree on that point. I said that we needed to rent out and then probably even to sell the land. And actually, they say, no, we shouldn't do that. It's our land and everything. Well, okay, it's unknown in which way. I just assume that this could be, I mean, I lived there. So there were I knew some circumstances there. But that was summer, yes, that you agree something with the relatives or with the friends who had some equipment maybe, because they don't have their own equipment. So your father used the equipment of other persons. Okay, and actually, as the real income that he got, yes, I went to the father and asked him what was actually the income. I wanted to clarify that. And they said that That's 15, 16, 14,000. That's what they said. I mean, I don't remember exactly because I filled out the declaration in 2023 for 2022. And they said that, no, we don't remember the exact number. Look at there. It should be somewhere in the tax service, this information. But the tax service doesn't have this information. That's why I'm asking the question. I cannot name the number because in 2023, in December, when I was filling out the declaration, just the drafts, I was also in the village for some time, and Dad was there, and I took his card, and together with him, we went into the account of the tax service, and this reflected the 16,000. And okay, thank you. I understand these explanations, but still I insist that in the materials there is a certificate from the register which doesn't show the sum. But still, could you tell me, in your opinion, does this income match regular capacities of getting income from the use of a land plot of this size? I believe it depends on the situation. It depends on the year as well. Again, it's my assumptions given common sense and my experience of communicating with parents and experience in agriculture. I mean, I'm a person from the village. I'm not far from that. But until 2019, I lived there. So, well, it is communicated with them about the land and everything. I believe that this sum can be realistic. There could be also even losses, no incomes received. Because again, just in my opinion, just briefly, from the outside, it seems that villagers like 5, 8, 11 hectares of land, but actually they get very small income from that in reality, because I mean they're not latifundis. You can actually come and see in which conditions they live. Thank you, Mykola. You also told your dad that you changed the place of residence from Mironovka to Kiev, and this was associated with the fact that there was bad internet and you had to work, and in Kiev you could have that internet. In 2022, you got a payout of 16,000 as an IDP. Could you tell me, in your opinion, is the goal of this payout a relevant reason for the reasons that forced you to change your place of residence? I actually noted that when I answered the question that I didn't look at Kharkiv for security reasons. I noted that. So from this point of view, yes, there is direct connection with the internal displacement. Okay, thank you. Could you tell me, in the question of the candidate, you talked about the activities of the first period of the entrepreneurial activities as an individual entrepreneur. That's 2023. And this period lasted for 6 months. During this period, you concluded one agreement and you received 76,000 of income, more or less. Is it actually real? Yes. But why in 5 months after registration of individual entrepreneur, you actually suspended, you terminated your registration? That was the first attempt. As I told you, with time, I had that thought that it's necessary to use these opportunities, that there is common experience and skills. You shouldn't be waiting for something, you should be actively doing things. And well, I decided to register entrepreneurship, and moreover, I can say, when I received this proposal, I can say that I was really thinking about it, but I wasn't sure. I was actually a bit scared I mean, so the entrepreneurial activities, you have to report all the time. What do you forget things? Yeah, it's clear. Thanks. Could you tell me this agreement, service agreement, its subject was an expert evaluation of the provisions of new criminal code of Ukraine? Yes, and obviously it is for that agreement that you had to register yourself as an individual entrepreneur. Well, among other things. And you didn't get any other incomes. No. Could you tell me? How did it just turn out that this registration was terminated so fast? As far as I know, this is a long process. There should be a tax service check. Actually, no, it's 5 minutes. Yeah, India. It's both creating and terminating. Okay. In the end of the same year, you concluded 2 agreements for similar service, also an expert evaluation of situational tasks for testing. And that was September and November. You didn't need to register as an individual entrepreneur. They refused. I knew that they wouldn't agree because in the previous years when we communicated with them, I said that I constantly provide these services as a trainer or write tests for different organizations. I mean, that's systematic activities actually. But why don't they have the right to organize my activities? But they just didn't agree. They never concluded an agreement. And the following year, already in 2024, you became an individual entrepreneur again. Yes. I mean, just explain to us that it doesn't look like optimization of income in tax aspect. Well, how to refute this doubt? Well, I'm saying that I'm telling what actually happened because I was hoping, and that was first attempt, I hoped for systematic activities. And for 6 months you worked as an individual entrepreneur, then you terminated your activities because there were no proposals and there were no opportunities for that. No, allow me just for 1 second. And at this time, the tax legislation was actually changing in summer of 2023. And I was afraid that I won't manage to follow those changes and I will incorrectly submit something there or not submit it. And so I just decided to save myself in this way. That's how I did. The same year, 2023, declared the royalties, about 12,000. Along with that, as I have noted, the subject of agreements that you got that income for was expert evaluation of provisions for tests. So could you explain the grounds to actually call this income as royalty as an expert lawyer? Well, why it happened like that? Why I declared like that? Because tests that I normally developed, I developed them upon commission of various organizations. And upon commission from this organization that you can see, it was once that I developed it, and they just formulated it differently. Not as a development and use of these works, but they actually wrote that as, I mean, I didn't pay attention to that. If the question is whether it was my mistake, then yes. Then it's my mistake because I didn't pay attention to what was written there. In the agreement, they wrote it different. Because for me, it was the same activity, test development, and they wrote expert reviewing of test tasks. Again, there is a mismatch here because you said that you developed, but then you provided. So it was 2 times. No, actually, this was technical. I remember that I was contacted once. They are searching for a pool of experts who are going to make those tests and to review them. And we worked. And then they sent in 1 agreement, the 2nd agreement. Honestly, I wasn't really dealing with it. For me, it was the most important to do my work. How much they pay me, that was different. Okay. That's it with the questions from me. Thank you. Colleagues, do you have any questions for the candidate? Okay, please. I have a sole question. I haven't clarified for myself the situation with your motivation
ваша відповідь, напевно,
So your answer probably shows your honesty, but at the same time, it kind of makes us doubtful about your motivation to be the judge in the high anti-corruption court. Could you please explain us in more details why we should be still convinced that you are going to duly perform your obligations, if of course there is a positive decision taken about you? Well, there are two criteria which were important why I made this choice and why I said that there is certain overlap. Well, this criteria, the subject jurisdiction of these two courts, and there's also geographic criteria. Geographic because there's advantage of high anti-corruption courts that Kiev is pretty far from Russia. And why Kharkiv? Because Kharkiv is my place. That's where my alma mater here. My family is in Kharkiv region, my closest people. So that's a big plus. As for jurisdiction, high anti-corruption courts has narrow specialization, that's true, and I'm interested in that. That's an advantage because you are focused on certain issues and that's it. You shouldn't be thinking about other issues when it's done. Again, there's rather wide jurisdiction in spite of some narrow things. But on the other hand, Kharkiv Court of Appeal is a court which presently there are lots of those that's against national security. So there's criminal and I think it was interesting for me, and that would show my contribution, possible contribution. Thank you. Okay. Thank you. Member of Commission Melnik, I would like to ask a rather simple question for the researcher about anti-corruption law and criminal law. Well, corruption legislation envisages the notion of gift. I mean, we have banned gifts, we have limited ban on gifts. So there is also the illegal profit, which is also used in criminal law. What is the difference of banned gift from this illegal profit? Well, the main difference between the banned gift and illicit profit is in the legal nature, because a gift cannot be received for illegal actions. It is received for legal actions, for the legal use of authority. And illicit profit is always received for the illegal use of authority. This directly is inferred from the notion of corruption. Corruption is providing illicit profit, proposal, or a promise for illegal use of authority. And violation of ban on the gift that actually is associated with the corruption but doesn't contain signs of corruption. It actually violates some restrictions which envisaged by the law but doesn't have signs of corruption. That's why we talk about illicit profit, because it is provided either free of charge or minimally at the market price. That's the first key difference, the legal nature. But I can even name others.
Thank you. So it means that if person gets a gift for committing actions using their duties, working duties, how we are going to qualify it as a corruptional bribe? So Article 368. Yeah. So we are not going to apply the Article 178 for using the official duties. No, it will be a corruptional offense, corruption bribe. Okay, thank you. And one short question. It's like a follow-up question to questions that you have already been asked. So at some moment, you tried to deviate and differentiate these two status, the status of a scholar and of a judge. So if you become a judge, you will need to limit yourselves in your academic creative activities. But again, it's not that clear how you differentiate, how you separate them. So do you think that when you become a judge, will you be limited as academic, as a specialist, as a scholar? Will you be limited in terms of critical assessments in your works of certain judicial decisions? Now, it will not be a ban. It will be so limitation, but a judge shall be as much as possible tolerant, well balanced, thoughtful about such decisions. You know, if I'm a scholar, yeah, I can be much more critical, criticizing such judicial decisions. And in my articles and my works, I can do it. And so it means if we choose you as a judge, we'll lose you as a scholar. Is it what you're trying to tell us? You know, I'm conscious about it and intentional about it. And in the judicial principles, it says that priority of interests of the judiciary shall be over any other activities.
Якщо можна, дуже коротке запитання, Микола Анатолійович.
Very short question.
На вашу позицію викладено в
Based on your position and
коротко, якщо можна почути обґрунтування.
so I would like to just to hear your justification. So about declarations. So declaration for 2023, you submitted it in 2024, and you have applied the relevant criteria of the minimum of the subsistence minimum. Subsistence minimum for 2023. So my question to you, in this case, subsistence minimum and the time of commitment of criminal offense. What do you consider as the time for commitment of criminal offense, specifically under these circumstances? I think that that's the time for filling a declaration and submitting a declaration. So based on this logic, how you are going to apply this criteria? Why then did you apply the subsistence minimum for 2023 if you use this logic? So speaking about the timing for commitment of a criminal offense, we are applying the tax minimum which existed at the moment of commitment of criminal offense. It was 2024. Yeah, I remember. And I can even give you other drawbacks of those declarations where I didn't have enough time or I didn't have any intention not to mention it. So I will have a very short question, if I may. I have no doubt that you have, powerful and a lot of academic works and contribution that you have made in the scholar activities. But please be concise and tell us, based on your practical experience of application in the court litigation, on the stage of investigation. So, and you understand, yeah, what I'm meaning here. So for us, it's important to understand that the fundamental theoretical knowledge that you have will be applied by you in practice as a future judge of the HHCC. That you have this capacity to apply this theoretical knowledge in practice. So, thank you. First of all, I don't have any experience at all at court. I didn't work as a judge. I didn't represent interests. Even more to say, under my work, I remember that I was a party to the court process. A long time ago, it was like in the midst of 2000. So there were certain circumstances. My parents were involved. I was just a witness. I was just observing. my other engagements in judicial processes were either related on evaluation and analyzing of core decisions, or also in 2025 I watched certain live streamings of the HSCC sessions. That's all. I have no experience, no other experience apart of this one. Then why I'm applying for this position of a judge, and why I think that I'm capable to be at this position? So first of all, that's what I mentioned, this knowledge and skills which are related, but indeed, it's not a very strong argument, but also I am inspired by those judges of the Supreme Court and of the High Anti-Corruption Court, which were scholars at the beginning and then became judges. I don't want to give names, but everyone I think understands that among judges of the Supreme Court and High Anti-Corruption Court, we have those judges who have scholar academic experience, and using this academic experience, they show great result at their judicial activities and work. Thank you.
Дякую, колеги. Пане Роберте, можливо, членів ГРЕМ є? Виникли.
Dear Robert, do you have any questions?
Yes, I believe that my colleague Jessica has a question.
Thank you, Mykola Anatoliiovych. This is a question about your previous, this question is about your previous work with the Institute of Legislative Ideas. It's mentioned in your curriculum vitae that you have worked with this organization. My understanding is this organization is based in Kyiv and is involved with the monitoring of the implementation of the UN Convention Against Corruption and the coalition of international coalition for that purpose. It is also an organization that has provided research and commentary on the anti-corruption system in Ukraine. Can you please describe your activities with this institute and the relevance of your work there that could contribute to your involvement as a potential future hack judge? Also, can you describe any potential conflicts of interest that you would potentially have with your former colleagues if you became a judge? How would your relationship with your colleagues who are involved in the civil society community, which provides important criticism of the anti-corruption system, how would your relationship with your former colleagues necessarily change? So there are two aspects to my question. First, to describe your work and exactly what role you had at the Institute for Legislative Ideas, and then to discuss how your relationship and the ethical issues related to your former colleagues would you become a judge. Please go ahead.
Добре.
Thank you. So the first question related to the details of my work. Indeed, Institute of Legislative Ideas, that's as a classic CSO or civil association. It was earlier considered as a center which was focused at anti-corruption policies and analysis of corresponding draft laws, but later, when I was already engaged into activities with such organization, and I was engaged after the start of the full-scale invasion, their focus has changed. That's on compensation of damage because of the aggression, that's on the issue of transposition of different directives, the issue of confiscation of assets, sanction policies, and that's a major part of their activities of this institute. The anti-corruption element is still there, but it's already not that major as it was before. So when we conclude working agreements, we always discuss what projects I will be engaged in. So was I engaged into anti-corruption projects? No, I was not engaged into anti-corruption projects because it was already reduced to minimum. Since 2022, they shifted their focus on the aggression and also ongoing events. So you can follow up their news on the website of the Institute of Legislative Ideas. So starting 2022, there are much less anti-corruption issues. Anyway, it's still there. But again, regarding myself and my work at this institute, and I'm actually proud of this work. So first of all, that's what I mentioned already, the analytics of the transposition of the directive of the EU 1226 of 2024, the practice of how this transposition has been done by the EU member states, because during a year they had this obligation to implement it, and some of them failed to do it. So it had also been translated into English. It's available there on the website. And later I was told that the European Commission actually referred to this study at certain events, and they recommended this study to be under attention, to take into consideration. And that's actually one of the things that I'm proud about. The issues of confiscation of the private assets of the aggressor citizens. But because, we have private assets and state assets, which are located in Belgium. These are two different things. And we are trying also to promote, to advocate this confiscation of private assets. Those people who violated sanction policies of the EU and USA, their assets should be confiscated, private assets, and you need to advocate those issues in order to have progress in it. There was second issue, yes, regarding the conflict of interest or the change of relations, with former. So I think that it depends on a specific factor, on a specific circumstances. Does it mean that if I become a judge, does it mean that I stop communicating with my former colleagues or former work members, team members from the Institute of Legislative Ideas? I think that communication shall not be stopped, generally speaking. That's not obligatory. The issue is what about I'm going to communicate with them, and what about what will be next activities of the Institute of Legislative Ideas. If they will continue activities focused specifically on sanction policies or compensation of damage, that's one thing. But if they're going to focus at reforms of the High Anti-Corruption Court, it's just an example, then you shall be very cautious and, thoughtful in your communications with former colleagues, so to say, because it could raise doubts from the external observer regarding your impartiality and objectivity.
Do you have any more questions?
On screen, Mary, Norman, no? Thank you. We're done, Mr. Chairman.
Добре.
Thank you.
Дякуємо.
Thank you.
Будемо завершувати співбесіду.
Then let's wrap up. Mr. Mykola, I give the floor to you for a final word. If you want to approach the Commission with some statements to add additional information, but please be concise. Thank you. Thank you for your attention. And I wish the PCA members and the Commission members to put all their efforts in order to select those candidates who are worth of it. And if I'm worth of being a judge, then I would be happy, but I wish also good luck to everyone else. That's not my ultimate goal, but yes, that's my final word. Thank you. Thank you for participation in this interview. Dear colleagues, then we announce